Before you answer a single question from a police officer in Canada, there are 3 words you need to say first. And by the end of this video, you will have them plus the 3 short lines that come after them, because those 4 lines together cover every police encounter you are ever likely to have. At your car window, at your front door, on the street. One system, 4 lines, same order every time. And I want to be straightforward with you about why this matters. Most people who get themselves into trouble in a police encounter are not undone by something investigators dug up after a lengthy investigation. They are undone by sentences they handed over for free in the first 5 minutes to someone who sounded friendly. It is almost never people with something serious to hide that this happens to. It is polite, reasonable people who thought that cooperation meant conversation and who did not realize until much later that the conversation was the evidence. But there is something else, and it is the reason this video exists specifically for Canada rather than simply repeating what you have already seen. A great many Canadians have learned their police encounter scripts from American YouTube videos, and some of what those videos teach does not translate here. Said the American way in Canada, one of those lines can actually work against you rather than protecting you. So we are going to fix that. Everything in this video is about Canadian law, the Charter of Rights and Freedoms, the Criminal Code of Canada, provincial highway traffic legislation. And where I quote the law, I am quoting the actual provision so you can read it yourself rather than taking my word for it. Line 1, are you detaining me or am I free to go? Those are your 3 words in the Canadian version. Not aggressive, not confrontational, just the question that forces the encounter to show you what it actually is. Because until you ask it, the encounter can be either thing. And the officer has no obligation to volunteer which. Every encounter with a Canadian police officer is one of 2 things. Either you are free to go, in which case the rules of the conversation are yours, or you are being detained, in which case there must be a legal power authorizing that detention, and it changes everything about what you should say next. The entire point of the question is that it cannot be both at once. Here is why the question works. Section 9 of the Canadian Charter of Rights and Freedoms states that everyone has the right not to be arbitrarily detained or imprisoned. The Supreme Court of Canada confirmed in R.V. Grant 2009 that a detention occurs when a reasonable person in your position would conclude they have no choice but to comply with a police direction. If you have been stopped and you stay because you feel you cannot leave, you are detained and the charter applies. If you are free to go and you did not know it, you may have stayed and answered questions you had no obligation to answer. Grant is worth understanding, not as an abstraction, but as a practical tool. The 3-part analysis the court laid out asked whether the police made a demand or direction to the person, whether there was a legal obligation to comply, and whether the circumstances created a psychological compulsion to comply with a direction that was not actually a legal obligation. When you ask, are you detaining me or am I free to go? You are forcing the officer to answer that 3rd question for you. Either the direction is a legal detention, in which case Section 10 applies immediately and fully, or it is not and you are free to leave. The question also does something else. The Supreme Court in Grant established that police cannot detain someone without reasonable grounds, and that a detention that consists purely of stopping someone without lawful basis in order to investigate is an arbitrary detention under Section 9. An officer who cannot answer, are you detaining me, does not have grounds for a detention. An officer who says, yes, you are being detained, has now told you something important, which is that the full suite of rights in Section 10 of the Charter now unambiguously applies. Section 10 of the Charter states that everyone has the right on arrest or detention to be informed promptly of the reasons, therefore, to retain and instruct counsel without delay, and to be informed of that right, and to have the validity of the detention determined by way of habeas corpus. The question invites the officer to trigger those obligations or to release you. There is no third option, and that is exactly why it is the first line. Line 2, and this is where the American script gets it wrong for a Canadian audience. And I want you to understand precisely why. Because getting this backwards is genuinely expensive. In the United States, the Fifth Amendment creates a right against self-incrimination that operates in a very specific way at the roadside. American drivers are taught to announce they are invoking their right to remain silent. And in that country, that invocation creates strong protection because the silence itself cannot be used against them in most circumstances. Canada is different. And you almost certainly already know the words that tell you so because you have heard them on Canadian police dramas without ever stopping to consider what they actually say. The standard Canadian caution, which police are required to give upon arrest or detention and before questioning, goes like this. You have the right to retain and instruct counsel without delay. You also have the right to free and immediate legal advice from duty counsel by making free calls to 1-800 Legal Aid. Do you understand? You are not obliged to say anything, but anything you do say may be used in evidence. Nothing in that caution is a warning that your silence will be used against you. And in that respect, Canada is different from England and Wales, which has a provision in their Criminal Justice and Public Order Act, allowing courts in certain circumstances to draw adverse inferences from silence. That provision does not exist in Canada in the same form. Section 7 of the Canadian Charter, as interpreted by the Supreme Court in RV, Noble, 1997, established that under the Canadian Evidence Act and the common law, silence during a police investigation cannot be used as evidence of guilt. The principle against self-incrimination is a principle of fundamental justice under Section 7 of the Charter. So why not just announce you are invoking your right to remain silent the American way? Because in Canada, the right to silence is a principle of fundamental justice, not a specific statutory invocation that must be formally announced. When you say, I am invoking my Fifth Amendment right to remain silent on a Canadian street, you have imported a foreign constitutional provision that carries no legal effect here, and you have made an ordinary interaction look like a confrontation with a script. You have signaled to the officer that you have prepared for this encounter in a way that draws attention. And the right you are trying to exercise exists in Canadian law, whether you announce it that way or not. Line 2 in Canada is simply this. I would prefer not to answer questions. That is all. It is not a legal formula, and it does not need to be. It says the same thing without dressing it in another country's constitution. It is a statement of preference, calmly made, that closes the door on questioning without opening a different door. If the officer pushes and asks why, the answer is the same line and the same tone. I would prefer not to answer questions. You do not explain, you do not justify, you do not fill the silence. The words are doing the work. Tone is the only variable, and calm is always the right tone. The right to silence that line rests on is confirmed in RV. Hebert, 1990, where the Supreme Court established that the right to silence is a fundamental common law right that the Charter reinforces, applying to any person detained by the state. The court in Hebert held that Section 7 of the Charter, which protects the right to life, liberty, and security of the person, encompasses the right to remain silent in the face of police questioning. You do not need to announce it in any particular formula for it to protect you. You simply need to exercise it, which is what the words do. R.V. Noble, 1997, went further. The Supreme Court held that the right to silence includes the right to have that silence respected, and that pretrial silence cannot be used as evidence of guilt at trial. An accused person who said nothing to police is entitled to have that silence treated as an exercise of a constitutional right, not as something a jury may use to infer consciousness of guilt. This is the protection the line rests on. It exists in Canadian law whether or not you announce it in any particular way. But the line makes your intention clear at the roadside, closes the conversational door, and prevents the well-meaning explanation that so often becomes the evidence. Line 3, I do not consent to any search. And I want to be honest with you about what this line does and does not do, because it is oversold in a great many places, and you deserve to know the truth. Saying this line does not stop a lawful search. If an officer has a legal power to search you, your vehicle, or your home, your objection changes nothing about whether the search is lawful. The power either exists or it does not, and your consent is not what determines whether a search is authorized. Section 8 of the Charter protects you from unreasonable search and seizure, but a reasonable search, meaning one conducted with proper legal authority, is not stopped by your objection. This cuts both ways, and the cut in your favor is where the line earns its place. In Canada, a consent search is a recognized exception to the warrant requirement. The Supreme Court confirmed in R.V. Wills, 1992, that a search conducted with valid consent is constitutionally reasonable and does not require the officer to establish independent grounds, which means that the moment you say yes, the analysis of whether the officer had grounds to search you disappears entirely. You handed it over. The question of whether the search should have happened is gone, settled by your agreement. When you say, I do not consent to any search, you remove that route. Any search that follows now requires the officer to have independent legal authority and to articulate what it is. Under Section 29 of the Criminal Code, an officer exercising a legal power of search must have it and must be able to state it. If the search happens anyway, it happens on the officer's authority and with the officer's stated grounds, and both of those can be examined afterward. And it does one more practical thing at the roadside. When an officer decides to proceed with a search, they are required under the Charter and at common law to tell you the reason. The Supreme Court's framework in R.V. Mann 2004 requires that any search accompanying an investigative detention be tailored to the specific circumstances that justified the detention and that the officer be able to articulate those circumstances. The words, I do not consent to any search, prompt the officer to articulate the grounds, which is information you should have and information that can be examined later. And it does one more practical thing at the roadside. When an officer decides to proceed with a search, they are required under the Charter and at common law to tell you the reason. The Supreme Court's framework in R.V. Mann 2004 requires that any search accompanying an investigative detention be tailored to the specific circumstances that justified the detention, and that the officer be able to articulate those circumstances. RV McDonald, 2014, addressed searches for public safety purposes, confirming that even a limited pat-down search for weapons requires that the officer have reasonable grounds to believe their safety or the safety of others is at risk. The words, "I do not consent to any search," prompt the officer to articulate the grounds for whatever action follows, which is information you should have and information that can be examined afterward by a lawyer or by a court assessing whether the search was lawful. The Section 242 framework from Arver's grant is the mechanism through which unlawfully obtained evidence can be excluded. The court weighs the seriousness of the charter breach, the impact on the charter-protected interests of the person, and society's interest in adjudication on the merits. Where a search was conducted without lawful authority and without valid consent, and something incriminating was found, that evidence may be excluded. Where the search was conducted with your consent, the analysis under Section 242 never begins because there was no breach. That is the value of the line in practical terms. There is one more version of this worth knowing. If the question is specifically about your phone, RV Fearon 2014 and RV Maraca 2017 both address the privacy interests in a cell phone. The Supreme Court has recognized that smartphones attract a strong and constitutionally protected, reasonable expectation of privacy. The court in Fearon held that a warrantless search of a cell phone incident to arrest is permissible only in limited circumstances, and even then must be subject to strict conditions. A search of your phone requires either a warrant or a recognized exception, and your consent is one such exception. "I do not consent to a search of my phone" is a sentence worth adding, specifically if the question ever arises at your window or door. Line 4, the wall. And this is the one you only ever need at the far end of a serious encounter, but it is the most valuable of the 4 lines by a considerable distance. "I want to speak to a lawyer." That is the line, not "I know my rights," not "you will be hearing from my lawyer." Just that, and then nothing else until you have spoken to one. This is the part I most want you to hear, because it is the single most misunderstood thing in the entire system. It is free at any hour of the day or night, free regardless of who you are or what you earn. Every person who is arrested or detained in Canada has the right under Section 10B of the Charter to retain and instruct counsel without delay and to be informed of that right. And in addition to the right to your own retained lawyer, duty counsel is available 24 hours a day through the legal aid system in every province in Canada. You do not need to have money. You do not need to have a lawyer already. You ask for duty counsel, and they are made available to you by phone before any questioning begins. The Supreme Court confirmed in Arver Bartle 1994 that upon arrest or detention, the police must inform you of your right to counsel, facilitate your right to retain and instruct counsel, and refrain from questioning until you have had a reasonable opportunity to do so. These are not courtesies. They are constitutionally required steps, and questioning that occurs before they have been fulfilled may result in the exclusion of evidence under Section 242 of the Charter. The Supreme Court confirmed in R. V. 1 day, 8-1, and V. day, that day they with 34. Bartle, 1994, that upon arrest or detention, the police must inform you of your right to counsel, facilitate your right to retain and instruct counsel, and refrain from questioning until you have had a reasonable opportunity to do so. These are not courtesies, they are constitutionally required steps. And questioning that occurs before they have been fulfilled may result in the exclusion of evidence under Section 242 of the Charter. There is a version of this right that applies even before arrest, and it is one that most Canadians have never been told about. If police ask you to come to a police station for what they call a voluntary interview, meaning an interview at which you are not under arrest and are told you are free to leave, you still have the right to consult with a lawyer before that interview begins. The Supreme Court in R.V. Sinclair 2010 confirmed the scope of the right to counsel during custodial interrogation, and the common law and police policy in most provinces recognize that a person attending voluntarily for an interview should be advised that they may have a lawyer present or consult one beforehand. You are not under any obligation to attend a voluntary interview without legal advice. I want to speak to a lawyer before I come in is a sentence you are entitled to say. And it changes nothing about your cooperation with a legitimate investigation while protecting everything that matters. In the 15 years I have worked in this system, I have never met a person who regretted waiting for a lawyer before answering questions in a serious encounter. I have met a great many people who deeply regretted the 20 minutes of conversation they engaged in while waiting for one to arrive. The conversations that happen in those 20 minutes are the ones that close files. There is also the at your door scenario that is worth spending a moment on, because many people assume the rules are the same at their front door as on the street. They are not. At your home, Section 8 of the Charter applies with particular force. The Supreme Court confirmed in R.V. Feeney 1997 that police generally require a warrant to enter a private dwelling to make an arrest, subject to narrow exceptions for hot pursuit and exigent circumstances. At your door, none of the highway traffic obligations apply. There is no requirement to produce any document, no requirement to identify yourself as a driver, no requirement to account for your evening. The same four lines apply at your door and in some respects apply with more force. Are you detaining me, or am I free to close this door? I would prefer not to answer questions. I do not consent to any search of my home. I want to speak to a lawyer. These are the same lines in a context where the law is, if anything, more clearly on your side. Now, there is a critical category where some of this stops being optional, and this is where the American videos can get Canadians into serious trouble by importing rules that simply do not exist here. The moment you are driving a vehicle on a road in Canada, specific obligations arise that you cannot decline. Under provincial highway traffic legislation across Canada, in Ontario, Sections 7 and 33 of the Highway Traffic Act, in British Columbia, Section 83 of the Motor Vehicle Act, and the equivalent provisions in every other province, a driver must stop when directed to do so by a police officer in uniform, must produce their driver's license when asked, and must provide insurance and registration documents. Failing to do these things is not an exercise of your rights. It is a provincial offense, and in some circumstances, a criminal one under Section 249.1 of the Criminal Code, which means the American line, "I do not have to identify myself," is factually wrong the moment you are behind the wheel in Canada. Said at a roadside stop, it can turn an encounter that was going nowhere into a charge you handed yourself entirely by yourself in one sentence. The rule that holds the whole system together is this: do the things the law actually requires, fully and without argument. Then stop. The legal obligations are narrow, they are written down, and everything past them is you volunteering. So here are the 4 lines in order. Are you detaining me, or am I free to go? That is the question that forces the encounter to declare itself. The officer must answer it. If you are free to go, you go. If you are being detained, everything that follows has to be justified by legal authority. I would prefer not to answer questions. That closes the door on fishing. Not aggressively, not with a constitutional announcement borrowed from another country, a stated preference, calmly made. I do not consent to any search. That removes the easiest and most common route to a warrantless search, the one that requires nothing from the officer except your agreement. I want to speak to a lawyer. The wall, free, constitutionally protected, and the single most protective thing you can say at the far end of a serious encounter. Not one of those 4 lines is rude. Not one requires you to know a single section number in the moment. That is the point of a system. You are not trying to remember law under pressure. You are remembering 4 short sentences in a fixed order and saying them in the tone you would use asking a stranger for directions. Calm, quiet, without performance. The words are doing the work. The moment you add attitude to them, you have changed what the encounter is about, and it stops being about the law. If you take only one thing from this video, take the first. Are you detaining me, or am I free to go? It is the question that decides everything after it, and it is the question almost nobody asks. Send this to whoever in your family does the late drive home or the early morning commute, because that is the encounter where all 4 of these come up at once, and it is the encounter where being politely helpful has cost more people more money than anything else I have seen in this work. Subscribe so you know this before you need it, not after.